Hello, everyone. My name is Cliff Davis with Roberts, Markel, Weinberg, Butler, Haley. I want to thank everyone for joining me today. We're going to have a little discussion about deed restriction enforcement of political signs and other types of displays. Talk about a couple other things too. Talk about regulating political signs, sharing tips on responding to social media comments. And we're going to address how POA should handle media requests. Talk a little bit about that also, but primarily we're going to talk about signs and displays. So as everyone may know, there's protection in the law for political signs. It was originally in the Texas Property Code. In the last session, they moved it to the Texas Election Code section 259.002. And basically the law says that a POA may not enforce or adopt a restrictive covenant that prohibits an owner from displaying one or more signs advertising a candidate or measure for an election. So that last part is kind of some important terminology there. It has to be a candidate that is running for election or a measure that is on the ballot for a vote. Those are the types of political signs that are protected. We'll move on. The law allows signs to be placed on or after the 90th day before an election, so 90 days before, and the signs must be removed before the 10th day after the election. And I think one thing we need to point out here is that this statute doesn't necessarily allow you to adopt a policy that prohibits signs. So a lot of associations have in their deed restrictions, there can be no signs on a property. What this law does is says, even if you have that restriction, you can't prohibit these types of political signs. So it's important to keep in mind that you have to have an underlying restriction, or you have to have the underlying authority in your governing documents, if you don't have a sign restriction, to adopt a rule against signs. But whatever you do with signs, you can't prohibit political signs. Let's go on. There are some things you can do with signs, with political signs though. You can require that they be ground mounted. You can require, prohibit more than one sign for each candidate or measure that's on the ballot. And there's some additional. You can prohibit the types of materials that can be used. If they're attached to the house, you can regulate that. You can regulate if they're painted on architectural surfaces, if they threaten the public safety, and you can regulate the size of those. Or if they violate a law, you can regulate them, or if they contain offensive language. So that you do have some authority to regulate these political signs, but you can't prohibit them altogether as long as they meet the requirements of the statute regarding if they are for a candidate that's up for election, for a measure that's up for election, and as long as they meet the other requirements, including the size requirements and the way the signs are made. The law also allows the POA to remove the sign from the property, and this presents kind of a question is, even though you have that authority, do you want to exercise it? You know, you've got to think about and be cautious about always going on someone's property. And, you know, in this case, you have the authority to go on the property and remove a sign that violates a restriction. However, like I said, you need to be cautious about how you exercise that authority. And sometimes it may just be better to write a letter. You know, this is similar to a self-help authority in the restrictions that may give you the right to go on someone's property and replace the siding on their house. Question is, do you really want to do that, or do you just want to pursue it as a violation when you see it? So there's a question, especially these days, of other types of signs. Black Lives Matter, Blue Lives Matter, other causes that are out there. They're very controversial. There's a lot of emotion related to these things, and a lot of people consider these as political issues. But keep in mind what we just talked about, that the protection for political signs is for a candidate running for election or a measure that's on the ballot. So if the sign is not related to something that can be voted on, or it's not related to a candidate that can be voted on, it doesn't fall into the protection of the statute regarding political signs. And then the question becomes, how do you handle those types of signs? And that's something that now can create a lot of emotion in the neighborhood, and a lot of feelings, strong feelings about it. So, what we've been getting a lot of phone calls about those types of signs. And what we've told people is, look, if you have a restriction or a rule or a policy that prohibits signs, and these signs are in violation, maybe a good idea is to send a general letter out reminding everybody that, hey, we're a deed restricted community. We've got a regulation against signs. If your sign is not one of these, and you would list the protection of the political signs, your sign is a violation. And as of this date, we're going to start enforcing our restriction. So try to address it that way as a general, hey, we're reminding you of, we have restrictions, the purpose of the restrictions, what the purpose of the restriction is, that there are certain types of signs that are allowed by law, even if your restrictions prohibit signs altogether. And as of this date, we're going to move forward with pursuing everyone that has a sign up that violates our restrictions. One of the other types of displays that the law protects is certain types of religious displays. And if you look at this law, in several areas of it, it seems to be very specific. It talks about religious displays that are affixed to the entry of the owner or resident's dwelling. It mentions that a few times, and this law confuses a lot of people because they think it protects anything, and it really doesn't. This law was actually written for a very specific type of religious symbol. The Jewish faith has a practice of putting on their door, on the door frame of a door, a religious symbol called a mezuzah. And you wonder, and that's what this law is really protecting. And this is one of those things where you wonder, how does a law like this get adopted? And I can actually tell you how this one happened. I was representing a condominium association. The condominium association had a rule that prohibited any type of anything posted in the door or in the hallway. And this was a condominium where there was a hallway with all the doors facing inward. So you couldn't put anything, any type of decoration, nothing. We got a complaint from that association that this item, a mezuzah, had been placed on the door, and the association wrote a violation letter. And the tenants who were living there responded by filing a lawsuit in federal court on the grounds that this was restricting their religious freedom or violating their religious freedoms. And the judge in the federal court called us in for a meeting and said, look, this is a rule that doesn't signal out religion. It doesn't address a specific religion. It's just a neutral rule that says you can't have anything. So there's really nothing wrong with this rule. And he told the tenants that your options are, you can dismiss this lawsuit or I'll dismiss it for you. And they dismissed it, and they said, we'll address this through the legislature. And the result of that was this law that will allow people to put a religious symbol that's no larger than 5 inches by 5 inches or 25 square inches on their door frame or on the door to their dwelling. Let's go on to the next one. And of course, with religious symbols, you do have some authority to regulate those if the symbol threatens public health or safety, if it violates a law, if it contains offensive language, kind of some of the same things on political signs, if it's on a location other than the entry door or door frame, or extends past the outer edge of the door frame. So you see, this law is written neutral too. It doesn't address any specific religion or any specific religious symbol, but it was aimed at one very specific religious symbol. Let's go on to the next one. And again, here, the law allows you to remove an item displayed in violation of a restrictive covenant. So again, it's one of those things where I'd probably counsel you to, before you go on a property and remove a religious symbol or even a sign that violates the restrictions, that first you write a letter and let the people know that, hey, what you're doing violates the restrictions. We've got the authority to remove it. We would prefer that you remove it before we have to exercise our authority to do that. Another big topic with associations is holiday decorations. And you'll have those people that put up decorations and then leave them there forever. And a lot of associations have adopted rules and restrictions about how to address holiday decorations. And typically they're kind of the same, in the same vein as political sign. They'll say that, you can put up holiday decorations maybe 30 days before the holidays and some time period after the holiday to take it down. One thing you have to keep in mind, for example, in the most Christian religions with regard to Christmas, that Christmas doesn't end until January 5th, which is called the Epiphany Eve, or the 12th night. And if you have a holiday decoration rule that says you have to remove them within 7 days or 10 days of the holiday, that would force people to remove their Christmas decorations before this January 5th date. And so you really want to think about what you're doing if you're adopting these kind of regulations. Be reasonable. Obviously, enforcement needs to be equal to everyone, and the question sometimes becomes, they're saying that this is a holiday and it's really not. And those are issues you have to just kind of handle on a case-by-case basis and consult with your attorney to see how those things should be handled. Other types of sign and displays, and we're just going to talk briefly about those, is flags. So if you have a restriction that says that no flags are allowed, again here, there's protection in the Texas Property Code that protects 3 types of flags: the American flag, the flag of the United States, the flag of the state of Texas, and the flags of United States military. So Coast Guard, Air Force, Army, I guess Space Force now is a branch of the US military. The Property Code gives protection for those types. And again, the Property Code allows you to have some guidelines about how those flags have to be maintained. They let you, things like the flag has to be in good shape. It has to be flown in accordance with certain rules and regulations that are applicable to flags. So that there are some guidelines you can have, but you can't stop people from flying those flags. Other types of displays you're going to see out there are these happy birthday signs or school spirit signs. And an issue that is a big issue in a lot of associations is they'll have a restriction that says no signs, but they'll kind of look the other way for these types of signs, for school spirit or these happy birthday signs or some other types of seasonal signs. And then when they get a sign they don't like, they want to enforce the restriction against it. And that can lead to issues, because if the restriction is no signs, that means no signs, other than obviously political signs that are protected by law. So when you go and you try to pursue somebody who's put up a 4-by-5 foot sign in their yard that the board doesn't like, and they turn around and say, well, what about these 30 houses that have a school spirit sign? That will be an issue. And you want to try to address those beforehand. If you've got a restriction, you may need to think a total sign prohibition restriction. You may want to think about amending the restrictions to allow certain types of signs. If your sign prohibition is adopted through a policy, you may want to flesh that out and say, we're going to allow security signs that are of a certain size. We're going to allow school spirit signs of a certain size. We'll allow happy birthday signs, as long as they're only there for a specific number of days. So there's ways to address that, but you just got to keep that in mind, that when you got a no sign prohibition, that means no signs. So we're going to switch gears here a little bit, and we're going to talk about social media complaints. So social media is a big thing, and now with a lot of time on people's hands, a lot of them have taken to social media to vent frustrations, and a lot of association boards are feeling the effects of that venting. So we recommend that you have a social media policy. And if you don't have one, now might be the time to think about getting one. Now, typically what that do is try to set some guidelines of what is or is not allowed. And these really only apply to social media that is governed by the association or controlled by the association, of what you will or won't allow. A lot of times you might not want to have a social media vehicle where you allow owners to post things, because ultimately at some point that might get ugly. Or if you let people post, you want to have some rules and regulations in place so that when somebody does something that's offensive, you can point to a rule that says why they can't do that. Otherwise, they think you're just making it up as you go along, and you're singling them out for something that they said, but you're not doing it for other people. And again, as with all these types of matters, rules, regulations, enforcement of restrictions, you need to enforce consistently against everyone. So, what's good for one person is good for others. And if you pursue one person for saying something bad, you've got to make sure you're consistently enforcing other people that may put something offensive on social media. And it's always better to have a policy in place, like I said, to avoid the charge that you're making up the rules as you go along. So the next slide talks about unofficial pages a little bit, and those are really the biggest problem that we hear from boards about, is that somebody is saying something mean about me, or they're spreading false information. And you've got to be careful with those. We generally advise boards not to respond to unofficial social media, because really you can't win an argument on social media. You're not going to satisfy somebody who's upset about something. They're either going to respond and deny what you say, or they'll twist it a little bit. So it's really not a good idea, we think, to get into these social media arguments with people. And even if a board member says, well, I'm acting as an owner and not the board, we don't think that really flies. When people see a board member say something on social media, they generally take that as coming from the board. So our advice to board members is, do not get on social media, do not engage on these next door arguments. And keep in mind that whatever you say, people are going to think that that's coming from the board. If there is false information being spread, or information that's not factual for some reason, there's ways to address that. And the way is to respond in an official manner. And you do that by either posting correct information on your social media page. You can say, there is a rumor in the community that X is happening. Here are the facts. Put the facts in there. Send a letter to everybody. Send an email blast to directly address those things. And you want to address those with facts. So in the end, there's really not much you can do. Some of these social media, next door type things are out of control. One thing you can probably take heart is that the only people reading those is typically the people that are mad. It's usually a small, very vocal group of people that are reading those. If you see something you don't like, don't respond on that. Respond through an official source with facts. Transparency is the biggest complaint. I'm sure that if you're on a board, that's what you hear. If as a manager, that's what you hear from owners, is where is the communication? And the best thing you can do is try to communicate as often as possible through as many means as possible: website, social media, email blasts, to try to get information out there. A lot of times I find at meetings that some owner comes in and complains about the communication, and the board says, well, do we have your email? No. Do you know that we have a website? No. Do you know we have a Facebook page that pushes out information about community events and other community news? No. So you want to try to engage all your owners to register their email and be aware of the way that the association pushes out official information. So in addressing complaints, you can always, if there's something on there that may be defamatory or inflammatory, you can send a letter to the owner to ask that they remove it. We write those letters. We say, what you're saying could result in a libel or defamation claim, or what you're saying is not correct. We're asking you to remove it. We hint at vague further legal action sometimes if they don't take care of that. The issue I have when I talk to board about that, they say, well, we want you to write a letter, and we want you to say this, this, and this. And I tell them that, we can write a letter stating what we think is wrong about what they're doing and why they should stop. But a lot of times, what that results in is the social person making all these posts takes that letter, puts it on their social media, and says, look, they're trying to silence me. They've got a lawyer threatening to sue me or telling me I better stop or else. Again, sometimes the best response may be no response to social media other than pushing out information through official sources to try to address what they're saying to the people that are actually listening. So media requests, we'll talk about them just for a second here. Last few years, we've seen it a lot. I'm sure some of the managers out there have seen it a lot, is that media is becoming more involved in HOA, and typically it's been our experience is that they're not doing it because the HOA is doing something good. They've heard about something that has been presented to them as some type of outrage. That's good news for news channels to run as the big bad POA. And so, what should you do if you receive those? Typically we would say if you're on a board, or if you should direct that to your management company or attorney and talk about how to respond. In some cases, no response may be the answer, but sometimes no response is not good, especially when you've got factual information that you can point to and tell the truth and get it out there, and try to let people know what is actually going on, not what just the owner is saying about the bad things. So a lot of times you just have to stay the course. If you're doing the right thing, time is your friend. And that's discussed a little bit, I think, on the next slide. But time is your friend. If you're doing the right thing, eventually people will figure out that the person yelling and screaming is a person that yells and screams about everything. That's the person that's on social media saying insane things about what the association is doing. So, really it's up to you to just make sure that you're being reasonable and that you're doing the right thing to avoid these disputes. But in some cases, you can't avoid social media disputes. You can't avoid people calling the media and giving the media incorrect information. And a lot of the mistakes I see boards make is that they become defensive too quickly, or they become defensive at all, when really all it takes is a measured response to that. And I see that a lot in meetings when somebody will stand up, an owner will stand up and kind of accuse the board of doing something. And nobody likes to be confronted. Nobody likes to be told they're doing something incorrectly. And a lot of boards would just need to take a deep breath and respond in a calm voice with facts of, no, you're wrong, this is why you're wrong, and explain that to the owners. And it's the same in person as it is on social media and with the media request, is that take a deep breath, respond with a measured response that is factual in nature. So we've kind of blasted through this today. Talked about a few hot button items. Right now, the biggest hot button item is the signage that really is not protected political signage. And I wouldn't be too heavy-handed in addressing it. Like I said, a letter may serve you well, a general letter reminding people what the rules are, and that the board will start enforcing the restrictions at some point. Remind people in that letter what is protected by statute, the types of signs or the types of displays or whatever it is again, it all comes back down to trying to get facts out there and not emotion. And enforcing the things we talked about today, or restrictions in general, consistent, equal enforcement. You all know that when you write somebody a letter, a lot of times the first thing they're going to do is, what about this person, this person, and this person? And my advice to managers and boards is to say, give us specific information, tell us the address of what you're complaining about, and look into everything that they are saying to see if it is a violation. And if it's a violation that you're not yet have not yet addressed, go ahead and address it. If you file a lawsuit against somebody for a violation of a restriction and they point out all these other violations, you need to show that you are also pursuing them. Generally, in pre-litigation, you don't give out the details of what else you're doing, but in a lawsuit, it can be made known public of what similar type restrictions you are enforcing or you aren't enforcing against people. And anytime you're not enforcing a violation that's similar to the violation that you're suing someone over, that's going to be a problem in that lawsuit. And again, we've kind of implied it and said it a few times, you've got to be reasonable in how you handle these things. That's really the best advice to all boards. Take a deep breath, be reasonable, do the right thing, and you'll avoid a lot of trouble. You're not going to avoid the people that get on social media and complain, because there are some people and that's just what they do. And you don't want to engage them. You want to respond with facts, but not engage in an argument that you can never win on social media with them. Let's see, we got a question before, and at what point can the HOA draw the line on political statements? And I think that's kind of what we talked about is, first you need to see what restrictions you have, and keep in mind that the law gives protection for political signs, for religious displays. So if you've got a restriction that addresses those, you can enforce it up to the point that whatever it is, the sign or the display is protected by the law, or the flag that's protected by law. But the best way to start some of those, especially in these times, might be what I talked about, is just trying to get the word out that, hey, let's remind everybody this is what the rules are. I think that is all that I have today. That was a quick one. Everybody can get out and go to lunch.
Hey, Cliff, we've
Yes.
got quite a few questions if you want to take a few.
Sure.
All right, so I'll start at the top. We'll go back to political signs. Are there any allowances for height restrictions for ground mounted? For example, can I use 10-foot poles to post my sign?
So ground mounted, I know that there's a size restriction of 4x6, but I don't know that there's a specific height restriction in the statute. I'm taking a look at it real quick here. There is not a specific height restriction. That might be something then that you want to specifically address. First, see if your restrictions contain any limitations on signs. And I think if they contain a height restriction, you could enforce that on the political sign. But if not, we've more and more have people adopting political sign guidelines, and that might be something you can address in those guidelines. And typically those guidelines more or less kind of recite what the statute is. But again, it's something that's put in writing, filed with the county, and something you can point to when there's an issue.
All right, next question. So how do we handle political flags? In particular, one that displays vulgar language.
Well, that's not protected. So again, you need to go back to your documents and see, do we have a restriction that addresses that? So if you've got a no flag restriction, that's a violation of that restriction. The only thing that are protected flag-wise are the US flag, the state of Texas flag, and flags for branches of the armed forces. But the point being is that you've got to have a restriction that violates. Now that may also, if you don't have a specific restriction, you can see if your restrictions have a nuisance annoyance clause, and if you've got complaints from neighbors, you could pursue it as a nuisance and annoyance.
All right, next question. So is an anti-candidate sign, for example, dump Trump, allowed, and that is not for a political candidate?
Oh, that's a good one. Let me look back at the statute. So the statute specifically says one or more signs advertising a candidate or measure for an election. So it doesn't specifically address an anti-candidate sign. It just says advertising, and it doesn't necessarily say good advertising or bad. I would tend to say that might be an allowed political sign because it is talking about a candidate. And again, like I said, the statute doesn't say it's a sign for a candidate. It just says a sign advertising a candidate, and that could be good or bad. I think I'm going to land on that is a political sign.
All right, so next question, we're going to go to flags. So can associations adopt restrictions that include the flag must be lit at night?
I don't have that statute in front of me, but I believe that the statute addresses some flag regulations that are out there. I might have to try to answer that one, do a look into that and respond to that person individually.
All right. So next question. If an association is not enforcing their rules regarding religious displays at all, can the association take action against signs that homeowners say are part of their religious belief / symbols?
So, again, this comes down to, what do your restrictions say? So if you've got a restriction that the religious sign or religious display is violating, it can be enforced unless it falls within the very limited protection of the property code section that we talked about. The problem you have if you have a restriction that's being violated and you're not enforcing it is that you can lose the right to enforce that restriction at some point. There's a defense to deed restriction enforcement called waiver, to where if there's sufficient violations, that an association can lose the right to enforce it. So the advice would be, if you have something that's violating your restrictions, you should enforce your restrictions, or you should know that you could lose the right to enforce them. So it sounds like that might involve a couple of things: a sign violation and a religious display violation. So, you really need to see if there's a restriction that specifically prohibits whatever that the complaint is. And if you have that and there's no protection in the law, you should enforce your restrictions.
All right. So next question. In regards to common areas versus private property, does the law differentiate regarding political signs between the two? So can associations prohibit political signs in the common areas?
Yes, they can. So the common area is private property. The statute protects displaying on an owner's property. So the common area is typically land that's, and this is for non-condominium associations, is typically land that is owned by the association, meaning the association has a deed saying we own this. And typically your governing documents, most of them say that the association can adopt rules on common area. So the association can ban them by adopting a rule, or if somebody trespasses on or puts a sign on property they don't own, the property owner can remove that sign.
All right.
But the bottom line is, yes, the association can not allow political signs on common area.
Great. Leslie, if you email Cliff at cdavis@rmwbh.com your question, he'll need to take a look at the specific CCRs to give you a better answer to your question.
And is that all? Is there any other questions?
Oh, there's a few more. We got a few more here, Cliff.
All right.
Yep. So let's see, going down the list. Can an HOA focus on reprimanding the most egregious situations for political signage, i.e. obscenity versus all rules, i.e. multiple signs? Their concern is feeding the fire in this environment.
Right. Well, what is most egregious is a matter of opinion. And that becomes a problem in enforcement on not just signs, is that, well, we didn't pursue that because we didn't think it was as bad as that other one. If it's a violation, it's a violation. And when you start picking and choosing which violations you're going to pursue, you've got a problem. You've got a problem of, you can face an allegation of selective enforcement, discrimination. So, the answer is consistently and equally against all. If it's a violation, it's a violation, and you should enforce. And again, if you try not to fan the flames, we talked about the letter being sent out saying, hey, this is what's allowed as of this date. This is what we're going to pursue. You can put a lot of flowery language in there. I typically put in my letters like that, keep in mind the deed restrictions are an obligation you voluntarily took upon yourself when you bought property in this neighborhood, and they're intended, to keep property values up for everyone. And there's certain rules in place, and those rules need to be enforced, or it's going to affect all of our property values.
All right. Next question. So this is an interesting one pertaining to, especially with the mail-in ballots. So what is the 90 days from date of election? Because of the mail-in ballots and early voting, does that make it a moving target?
No, I think the date of election is the actual day where you can go to the poll and vote, or the last day you can go to the poll and vote, which is what, November 4th or whatever it is. So there's an election day that's set. It's just that you can vote before that date with some of these new methods that are being used.
All right. Next question. So is there a difference between a flag and, say, a ground-mounted wire lawn ornament?
Well, the simple answer is one's a flag and one's an ornament. Um, so, the question is still go back to the restrictions and see, does that violate? If you've got a restriction that says that every improvement has to be improvement of any type or character, or you may have some that specifically list out, statues, lawn ornaments, all those, you need to see if you can enforce that restriction or if it violates that restriction. But yeah, I think there is a difference between a flag and a ground mounted ornament.
All right, I know we've covered a lot of issues with the flags and signs, so this specific one, would a LGBTQ sign, flag, banner be protected?
No.
All right, I know some other things that we've had questions on are for bumper stickers. So, and other types of election stickers. Could they place those on a cause sign, say a Biden sticker on a BLM sign, a Trump sticker on a BLM sign, or an LGBTQ sign, and those be protected political signs because they have the stickers?
I think arguably they're not protected because they're not just advertising a candidate or measure for an election. But that's a good question, and that is a gray area. It's just, when they pass these laws, people are ingenious about how they come up with something that doesn't really fit into the law. So really, I think, again, that's a case-by-case basis that you would want to consult with your attorney about to get their opinion on if they think that rises to the level of political sign, or if it's just kind of a subterfuge to try to make it look like a political sign.
All right. Here's an interesting question for you, Cliff. So can a board of directors advertise/advocate for a political party or cause? For example, putting a link to one party on its website.
I would, first off, I'd recommend against that. And keep in mind that there's restrictions on associations are generally organized as nonprofit corporations with the state of Texas. There can be implications for a nonprofit corporation that espouses or pushes a political viewpoint. And I don't pretend to know the ins and outs from that, but I know that is an issue. If anyone were to ask us, can we do this or should we do this? Our answer would be no. You should not. Right. A board of directors or an association should not push one political idea or political party or political candidate. You're right. Asking for trouble, and you may affect your nonprofit status.
Great, thanks for that answer. So next question, and this is, you've spoken on enforcing your restrictions constantly, but some associations have kind of relaxed a little during COVID on a variety of restrictions. And they're asking, is it appropriate we give leniency to one restriction versus another during this time?
I think if you delay in enforcing a restriction, that's not refusing to enforce the restriction or not enforcing the restriction. It's just when you're going to enforce that restriction is an issue that the board wants to decide. So I don't necessarily see a problem with that, especially due to the situation that's going on out there. But you don't want to get to the point where where the board says we're not going to enforce that restriction now or ever. But you can enforce restrictions in a few ways. Most associations have some kind of letter process that usually starts with a friendly letter that says, hey, you need to paint your house or you need to mow your yard. Well, there's nothing from stopping you from sending 6 friendly letters before you actually start sending letters that get a little more serious, and before you get to the 209 letter that talks about turning a matter over to your attorney. So, I don't necessarily think slow playing enforcement of the restriction is bad, as long as the intent is to never enforce the restriction.
All right, next question. So back to these birthday signs. Could they be interpreted as a holiday decoration and apply to your holiday restrictions?
You know, if your restrictions define them as holiday decorations, then I think that's fine. I mean, I think, you know, if you've got restrictions to say these are holiday decorations, restrict guidelines, I would think most people aren't thinking that's birthday. But the way to address that is, if you've got a set of rule, guidelines, or regulations, is to define what constitutes a holiday decoration, which can include birthday signs.
Okay, next question.
And I guess I just want to keep in mind on, you know, whenever you're adopting a rule or a regulation, you have to look for your authority to adopt that. So, you know, for example, a lot of declarations may say the board may adopt rules and regulations regarding the use and maintenance and appearance of the subdivision. Well, that's pretty broad authority. So you can adopt a lot of different rules, but you've got to have some authority somewhere to adopt any rule, policy, or guideline. You know, and that authority can be in your governing documents. It may be in the property code, which gives you the authority to adopt guidelines to regulate the things that we're talking about: signs, flags, generators. That gives you that authority to have some regulation on those. But you need to look for the power source that authorizes you to adopt a rule or regulation. And just keep that in mind when you're talking about, you know, we want to address this, is where do you have the authority to address that?
All right. All right. Back to political signs, and we've had a couple of questions on this. For people that have more than one candidate sign in their yard and the board wants them to only have one and wants to remove the others, do we say they should all be removed? Now, they haven't offered specifics on if it's more multiple signs for the same candidate or if it's multiple signs for different candidate.
I think that the statute allows a sign for different candidates. I don't think you have to make them choose. We're going to put a sign up for our, you know, our state rep, but not for the presidential election. But I think if you've got, you know, 5 signs for one candidate, that the statute would let you say you can have one sign for that candidate.
All right. Back to flags. So would installing a flagpole be considered an exterior modification and subject to ACC review?
Yes. You can require ACC review, but you just have to keep in mind that you can't say no if they're going to fly one of the allowed flags.
All right.
You can still try to regulate it that way to make sure that they are complying with your declaration and the statute.
Great. All right. Heather, to answer your questions, yes, we'll be happy to put the Q&A with the slides when we send it out. We're also, this presentation is recorded. It will go on our YouTube page within the next few days as well for everybody to review at their convenience. Let's see. Other than that, I think that wraps it up, Cliff.
Well, the only thing I just want to leave everyone with is, you know, if you've got a question and it's a quick and easy 5-minute question, and even if we don't represent you, you can give me a call and I'll try to help you out or point you in the right direction, and talk with you about any issues you want to talk about. So thanks for coming again. Hopefully this helps out a little bit. Hopefully it didn't just lead to more questions, but you know, a lot of times that's what the law does. Is it's like I said, people are very crafty about creating a situation that just doesn't quite fit into the confines of what the law says. And that's when you really need to talk with your attorney to determine how to proceed on those. But thanks a lot for coming.